Good day, ma'am. I am Jovel Sagusay from BSHM 3B, and this is my chapter 4 entitled Law on Partnership and Corporation. So, for any partnership to work, the element of trust is essential and it's more important than the resources or skills that the partners actually bring into a business. For corporation, a good governance and transparency is essential because of the public trust. This is according to Professor Frank Cavico, Nova Southeastern University. So before that, here's the list of the learning objectives. So the students are to able to differentiate the various kinds of partnership and corporation and the responsibilities of partners and incorporation, and to be able to identify the requirements in the formation and dissolution of partnership and corporation.
And next, this is the list of the topic outline.
First, law on partnership. So according to Article 1767, by the contract of partnership, two or more persons blend themselves to contribute money, property, or industry to a common fund with the intention of dividing the profit among themselves. So here's the discussion of law. So a partnership is an association of the two or more persons to carry on a co-owner of the business for profit. The definition of the partnership does not include religion, associations, conjugal partnership, and other of the similar nature because of the partnership as defined by law refers only to association, the purpose of which is to obtain profit to be distributed among the partners. So here's are the advantages of forming a partnership. First, easy to form, improve growth possibilities, freedom from bureaucracy. And we have also the disadvantages of forming a partnership. First is the stability, difficulty in obtaining large sum of capital, firm and tied to the act and judgment of one partner and as an agent, and lastly, difficulty in severing partnership ties. So here's the classification of partnership. So the first one is the according to the subject matter. So universal partnership. Universal partnership is a partnership where all of the partners contribute all of their properties, the common fund, and speak of no particular purpose of subject matter, as long as the purpose in forming in partnership is to obtain profit and it's not contrary to law, moral, public order, and public policy. Nowadays, self-dom is none to you experience business establishment forming a universal partnership. Next, particular partnership. A particular partnership has for its object determine things, their use of fruits or a specific undertaking or the exercise of the profession of vacation. Next is the according to liability. So general partnership. General partnership is composed of a general partner rather where liabilities extend to their personal properties. Next is limited partnership. Usually attach the word LDT or limited at the end of the company name. One formed by two or more persons having as a member one or more general partners or one or more limited partners where the liability of the latter of third person is limited to their capital contribution. Next is the according to duration. Partnership for a fixed term is one in which the term of its existence have been agreed upon expressly, as when there is a definite period, or impliedly as when the particular enterprises or transaction is undertaken. So the expiration of the term thus fixed or accomplishment of the particular undertaking specified will cause the automatic dissolution of the partnership. Next is the obligation of the partner. So the first obligation of the partner is money or property. If a partner promised to contribute money during the celebration of the contract and he fails to do so, he shall pay the interest and damages from the time he should have complied without need of any demand. If a partner promise to contribute to specific determined things, he must preserve the property, deliver and proofs from the time of agreement, warrant against eviction and hidden effects, transfer ownership of delivery to the partnership, pay damages for the delay without necessity of demand, and lastly, bear the risk of lease before delivery. Next, where contribution is industry. An industrial partner, a partner who merely contributed industry or services to a common fund, cannot engage in business for himself unless the partnership expressly permit him to do so. And if he should fail to do so, the capitalist partner may either include him from the firm of avail themselves of the benefits which he may have obtained in violation of this provision with a right and damages in their case. Next, obligation of the capitalist partner. A capitalist partner is a partner who contribute money and property to common fund, is prohibited from engaging in a business in competition with the partnership, unless there is a stipulation to the contrary. Otherwise, all profit of such a partner belong to the partnership and all losses shall be for his account. Next is responsibility between partnership and partner. So the partnership shall be responsible to every partner for the amounts he may have disbursed on behalf of the partnership. It shall also answer to each partner for the obligation he may have contributed in good faith in the interest of the partnership business and for risks and consequences of its management. Next is sharing of profit and loss among partners. So the contribution of the profit and losses shall be in conformity with the agreement. If only if the profit is agreed upon, the share is losses shall be in the same proportion. So a stipulation which includes one or more partners from any shared in the profit or losses is void. But an industrial partner shall not be liable for losses. In the absence of stipulation, the share is in the profit or losses shall be in the proportion to their respective capital contribution, except the industrial partner who shall receive a share of the profit as may be just equitable under the circumstances. Next is the property right of a partner. So a partner cannot assign his right with respect to the specific partnership property of the partner in the bond with debt or for a legal support. However, a partner cannot assign his share in the profit to the third person. The right to participate in the management is governed by stipulation of the partners. If none, all of the partners participate in management. The power of the managing partners appointed in the article of the partnership cannot be revoked despite opposition except by partners representing controlling interest and provide there is a just a lawful cause. However, powers are the managing partners appointed after the formation of the partnership cannot be revoked anytime. If two or more partners are appointed, managing a partners, each one may separated execute all act and administration but is opposed. The majority among the management or managing partner shall prevail, and if there is no majority, the partner owning controlling interest will decide. Next, liability of individual partners to third person. All partners include the industrial partner are liable for pro data with all their properties for contracts with their person provided. First is they were entered into the name and for the account of the partnership under his signature and by person authorized to act for the partnership, and lastly, the partnership assist and already exhausted. So all partnership are liable to solidarity with the partnership. So for example is a wrongful act and omission causing loss to a non-partner, and conversion of misappropriation of fund belonging to a stranger received in the usual course of business by partnership. Next is liability of the limited partner. So a limited partner is liable as a general. First is when he allow his surname to appear in the partnership name, and next is when he takes part in the control of the business. In this case, he shall have all the rights and power and be subject to all the restriction of general partner, except that as to the other partners, he shall be preferred as to be the return in his contribution and shared in the profit. Next is law on corporation. In section 2, corporation defined as is an artificial being created by operation of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or incident to its existence. So here's the kinds of corporation. First is the stock corporation. Stock corporation is one which has a capital stock divided into shared as it's authorized to distribute to a holder of such shares dividend or allotment of the surplus profit, retained earning of the basis of shared yield. A stock corporation is organized for profit, and governing body of stock corporation is usually the board of director. Next, non-stock corporation. Non-stock corporation is one where no part of its income is distributable as dividends to its member, trustees, or officers subject to the provision of the Code of Dissolution. A non-stock corporation is one not organized for profit. The governing body is usually the board of trustees. Next is the corporation de jure. A corporation organized in accordance with the requirements of law. Next is de facto corporation. A corporation where there exists a flaw in their corporation. Next is public corporation. Public corporation is one form of organized for the government of a portion of the state. It is created by its own character for the exercise of the public function. For example, is the Batangas City Municipality. Next is the private corporation. Private corporation is one formed for some private purpose, aim, or end. It is created by incorporation under the General Corporation Law. These include a government-owned and controlled corporation with the original character, and quasi-public corporation, a private corporation performing public functions. Next is corporation sole. One organized for the purpose of administering and managing as trustee the affair, property, and temporalities of any religious denomination, sect of church. In this corporation, there is only one incorporator. Next is elementary corporation is one organized for a charitable purpose. Next is domestic corporation. This means a corporation formed as organized and existing under the law of Philippines. Next is the foreign corporation. A corporation formed, organized, or existing under any law other than those of the Philippines and whose law allow Filipino citizen and corporation do business in their own country or state. So here's are the advantages of the corporate organization. First is strong separate juridical personality, limited liability to investor, free transferability of unit of ownership, centralized management through the board of director, professionalism, and lastly, easier to sell small amount of stock to raise capital. And here also the disadvantages of the corporate organization. First is extensive government regulation, double taxation, And lastly, activities unlimited by charter and various law. Next is the dissolution of the corporation. So corporation are dissolved as follows or the following. So first is voluntarily by filling the proper papers with the Securities and Exchange Commission. No hearing is required if there are no creditors affected, but a hearing is required where creditor are affected. Second is involuntarily upon verified complaints compliant filed with Securities and Exchange Commission upon notice and hearing and on ground authorized by law as in the following. First is fraud or misrepresentation as to the paid of capital of the corporation. Next is ultra virus act with or persistent despite SEC warning or the Republic versus Security and Credit Acceptance Corporation. Next is the continuous inactivity of the corporation for at least 5 years. Next is refusal to adopt or approve by law. Next is serious dissension in the corporation. Next is expiration of the term of the corporation. Southerning of corporation term under section 120 of the Corporation Code. Fifth is failure to organize and commence business within 2 years from the date issuance of certificate or incorporation, or lastly legislative dissolution. Corporate liquidation. So after the dissolution of the corporation, it's continued to exist the body corporate, but only for the purpose of enabling it to settle and close its affair, but not for the purpose of continuing the business for which it was established. So the liquidation of a partnership affair shall be for a period of 3 years. A dissolved corporation cannot extend corporate life during the 3 years liquidation period by amendment of its article of incorporation extended corporate term. However, it is corporation has the pending case with it filed during the 3 years liquidation period and it is still pending after said period. Then the stockholder should meet the transfer and all the rights of action to the trustee of that he can continue the case until its termination. And finally, it has been held that even after the lapse of the 3 years liquidation period, the officers and directors of the defunct corporation are the proper parties in interest insofar as they may be held personally liable for the unpaid deficiency tax assessment made against the defunct corporation. And that's all about my chapter 4. Thank you.